Welcome to our YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we'll be discussing the realities of challenging your former employer and the difficulties you can anticipate facing when you seek to attain what you, in all likelihood, rightly deserve, sometimes more than you deserve, sometimes less than what you deserve, but nevertheless, what you are, in all likelihood, legally entitled to. Because the fact of the matter is, former employers do not want to provide appropriate termination pay to most employees. Now, if you had a good relationship with your former employer and they understand the situation, they might well provide you something that is in line with what's legally appropriate. However, the reality is those situations are few and far between. Instead, what happens, partly because they have so much power both during the employment relationship and afterwards, is that employers will take advantage of the situation and push hard against their terminated, their fired, released employees and attempt to get them to settle to something less than what they could illegally attain. And that's just the stark reality because they hold the power, they hold their own purse strings, and they have expensive lawyers that they can pay for. And you got to remember, they're still operating, oftentimes still making lots of money, and the money that they spend is not necessarily their own personal money. It is, in fact, the money of the company. And it is the money that they're using, in part, that they would otherwise pay out to yourself and others. Because the reality is that these employers, when they give you the proverbial shaft and underpay you on your termination and underpay you through the course of your employment, they are not doing this in isolated circumstance. And this is what a lot of the lawyers fail to recognize and fail to appreciate and fail to deal with. If there is something happening to yourself, whether it's underpayments during the course of your employment and or underpayment of termination and severance pay at the time that you are fired or released or laid off of your job, this is rarely an isolated incident. It's a standard practice. And as such, the importance of keeping the price down, the cost down with respect to yourself is considerably more significant because they cannot set up a trend, they cannot set up a practice, they cannot concede, at least initially, to what your demands are. Because if it's simply a matter of an additional $5,000, $10,000, $20,000 to one individual, that would be not so problematic. And they would probably not be looking to spend significant legal fees agreeing to such an arrangement. The problem for most large and medium-sized companies is that they're not dealing with these singular incidences. They're looking at a company-wide perspective. And when you look at a company-wide perspective, if you start to increase the amount of termination pay, if you start to correct the underpayments, you're using now a multiplier effect. So if you increase the termination payouts, for example, for people that the employers perceive as non-productive, non-functional individuals, given that they're no longer working there, and you say, we're going to increase it by $10,000 because we have to, or because this is where we understand their position is. Well, if you're talking about terminated over a course of 5 years, 100 people from a larger company, 200 people, well, you're right away talking about millions of dollars. So that of itself is problematic. And we're just talking in small numbers right now. Because the fact of the matter is, oftentimes some of these larger corporations are talking of far greater numbers, far larger numbers that we're talking about, both with respect to termination severance packages and with respect to the number of people that are being let go from these companies. So it's ill-conceived for them, from a financial perspective, to simply concede on the one where it has the potential for a ripple effect. So instead, what they need to do, and what they typically do, is they take a hard line, especially at the outset. Their lawyers take a hard line, and they throw out stuff, and they claim stuff that doesn't necessarily have a whole lot of substance to it from a legal standard. Now, what's even more problematic, in my estimation at least, is the issue of underpayments during the course of one's employment. Now, one of the problems with underpayments is that it's a very difficult, but not necessarily impossible, but it's something that people do not want to do during the course of their employment. Because why would anybody take the risk of aggravating their employer with respect to seeking a slight increase, even though it's legally permissible, and challenging them? Because they know quite well that as soon as they do that, they're going to be one of the first people on the chopping block, somebody who's going to cause problems, and somebody who's going to cause a lot of cost for the employer, for the boss. And it's going to cut into their profits, and this is something they don't want to do. And then, even then, the fact of the matter is, understanding what the issues are with respect to underpayments during the course of one's employment is very difficult to discern. Because even though there is a lot of underpayments being done, a lot of it is not perceived by the companies themselves. They're not perceived by the companies, by their payroll staff, by their accounting staff, or by their lawyers. And this is a part due to the fact that these companies have grown so large, so pervasive, that they do not understand what is actually happening with respect to one of the most core aspects of their business, the core costs. And one of the core costs of their business is, in fact, payroll, because their employees tend to be a large part of their costs, ranging from anywhere from 30% to 60% of the costs of the company. And the fact of the matter is, the people in charge and the people who should be overseeing this find themselves either too busy or too focused on other aspects. So let's take an example, whether it's the accountants or the lawyers. They're focused on the big picture items. They're looking at the big transactions. They're dealing with the equipment purchases, the real property purchases, as opposed to the ongoing mundane payroll issues. They're not mathematicians oftentimes on the legal side, and the accountants are more concerned about tax matters, structuring, costing, maintaining revenue. And then there's another aspect that we have to think about, and that is the fact that if nobody is disclosing it or challenging it from the employee side, why is the employer going to be getting his people to start looking and attempting to identify where they're underpaying? That just doesn't happen. The goal is not to increase costs. The goal is to decrease costs. So everything that's being done from the employer's perspective is to find ways to decrease costs. So what does this mean? Well, it's pretty clear what it means. It means that they are constantly looking for how to cut stuff out. And if somebody does identify an area where there is the potential for underpayments to have been served and identified, then the question becomes, well, has anybody raised it? And given the fact that nobody has raised it, and if it is raised in a singular instance, it's quickly shut down and addressed. The fact of the matter is that underpayments are not something that they actively pursue. And it's very difficult for someone to address it. And when you do identify it and you bring it up to lawyers, the lawyers start to hedge and haw about it. And when they do discuss it, they realize that this is not an aspect that is of a limited character. There is more to it than simply a singular underpayment. Given the fact that it is oftentimes a practice that's been undertaken by that particular company. So they've been engaging in underpayments possibly for years and possibly exposing themselves to considerable amounts of liability. So we could be talking very easily about tens of thousands, hundreds of thousands, even millions of dollars in certain circumstances of underpayments happening within these companies. And if nobody's really raised it, and oftentimes it's a function of previous leadership, previous payroll staffs, they're not going to want to start bringing it up and say, well, we've now got to correct this because we just found it, it's not 100%, and nobody's challenging us. That's a very big problem that they don't want to address. So what are they looking to do instead? Well, they'll keep it nice and quiet and say, we'll just let it wait till the next group of CEO and president and CFO and legal counsel comes along, and if somebody does address it, they either have to find a way to deal with it or they have to pay it out. But we'll let it slide as long as we can let it slide, because in all likelihood, I'll be out of here, as opposed to addressing it and then undercutting myself as a CEO and allowing for significant losses to be realized, which are losses that were the responsibility of probably an earlier corporate administration. And nobody wants to take on the responsibility for somebody else's, because now you're looking at possibly losing your job because you're addressing the errors of the past administrations. You're possibly cutting back your bonuses, your stock options and the like, undercutting the profitability, creating dissension within the employee ranks. It is a very, very problematic situation. And for that reason, and all the other reasons we stated, you're not going to see them actively trying to challenge this stuff, take it on. Instead, what happens is they try to avoid this stuff, try to sweep it under the rug, and keep it silent. And they do that over and over and over again. And the lawyers are going to try to keep it quiet because that's what their instructions are. We're not paying this out. We don't believe it. Is there any chance of fighting it? Because they know full well that so long as you fight this stuff, you're going to have a very good shot at having a lot of people drop off when they challenge it. And that's a really big issue that you're dealing with, in the sense that you fight this stuff and they challenge you, and people can't go on and they can't fight it, especially when they're doing it as an individual action. And that's one of the major problems, is that you as an individual are fighting the behemoth of the corporation. You're out of a job now, you're looking for another job, you have to look for the financial security of your own family, and you're fighting this company who's trying to protect its financial interests. Because as we said, when you're fighting it and you're fighting them, you're not just fighting for yourself. All too often you're fighting for all these other employees. Or in another sense, we could say, your exposure that you're bringing to them is similarly exposure that they have company-wide. And whatever you are looking at oftentimes you can just multiply it by the number of employees that are in the company, and sometimes even the number of employees that were previously with the company, as to what the financial exposure is to them. And it shows you the rationale for them wanting to fight to pull out everything, because when they start to really look at it, they see that they have considerable financial liability. They might not see it at first, and this is another problem, is that they actually start to believe that they're in the right. And they're very rarely in the right when you've taken a proper and hard look, especially when your lawyers looked at it, because they're trying to skate by, and they've been relying upon payroll systems that are inadequate, inappropriate, or inefficient. And we say this with all sincerity because payroll is a function of, it's an operational process that is constantly pushed down. As we said before, the lawyers don't want to be involved with it, the accountants don't want to be involved with it. So it falls upon the lowly payroll staff and the payroll software that they're using. And all too often, the payroll software either is not up to date or is not even appropriate for the jurisdiction within which you are employed. Because payroll can shift from jurisdiction to jurisdiction, whether it's from province to province or state to state. The laws are oftentimes very specific. And the payroll software, it's just designed largely by computer programmers and salespeople with limited legal input. And that's the harsh reality that I've seen, especially in those jurisdictions where there is very specific legal requirements with respect to how employees need to be paid, how all their pay calculations are to be done. You can't simply be saying, oh, well, I'm just going to use a basic software system. It simply doesn't work. You can't just simply rely upon people who might not be adequately trained and not have the lawyers and the accountants involved from the outset of the business and dealing with all the critical changes. There's so much involved. As we said, you're oftentimes looking at 30 to 60% of a company's entire cost framework, and allowing that for an underpayment, it's atrocious that companies do not put enough time and effort into properly understanding, developing their payroll systems so that they are specific to their business and specific to the jurisdiction within which they are operating from. And it's even more challenging now that so many companies are multi-jurisdictional in nature. They operate throughout entire countries and in many countries. And in so doing, they rely upon a payroll office that's located in but one country, in one location. So in one jurisdiction of many. And oftentimes, even outsourcing it to another country. So if people are not necessarily familiar with it, not familiar with the nuances, or don't have an innate interest in how the payroll system works or should be working. And this causes very, very serious problems, at least in my professional estimation. And it's a major and a significant problem that needs to be addressed. You can't simply have this stuff operating without consequence. You need to really get into what the payroll system is doing. And employers tend not to do that. And it stems in part from the fact that all too often employers feel that they are paying way too much for their employees, and in so doing they make the cardinal mistake of saying, I'm paying too much, I'm not going to look to make sure I've got the correct payments. And in doing that, they expose themselves to very serious legal issues because the problems are there and the challenges are there that they need to be putting the time in. And when they don't, then the problems arise. And from the perspective of a terminated employee, they need to recognize that these problems do exist and that they do need to be addressed and to be tackled, because this is where you have oftentimes the greatest strength in your challenges to your former employer. They're not going to like it. They're going to fight it. But if you have strong legal basis there, you're going to be able to move forward very effectively. And that is what you need if you want to press forward and deal with this kind of stuff. You can't simply let it sit aside. You have to understand the challenges that you're going to face, because when you properly challenge an employer and you understand and your lawyer explains to you the scope of the deviations from the law, you need to recognize that you're in for a fight, because you're really challenging the whole basis upon which they are operating. And it's not going to be some nice, relaxing trip down to get your money, because you're shaking up the whole system. And you need to know that, and your lawyer needs to explain that to you, because it's problematic for most employers when an employee really knows what's going wrong and really knows how to challenge their former boss in the context of underpayments, both with respect to termination pay and severance and to the prior pay arrangement, because the issues all too often exist, and if you deal with them, they are of significant financial consequence to your former employer. And your former employer is most definitely going to want to push back, because it's not a pretty situation for them on so many different fronts, as we discussed. So if you find yourself in this kind of situation, take the time, speak to a knowledgeable legal counsel who is familiar with your jurisdiction, the laws there, and can properly process and understand where the underpayments are coming from. Because there's a lot more to it than simply saying, oh, well, you know what? I think I might have been underpaid. I don't really like the fact that I lost my job. Yeah, the employer has the ability to terminate you, but they don't have the ability to withhold the money that's due to yourself. And that's what you got to fight for, but also that's what you need to know how to deal with those situations. Well, best of luck in your situation, and we'll talk to you again. Thank you.